Let's talk about now a story that caught our eye here on Super 6 of a judge in the Allahabad High Court who deemed an assault, seemingly an attempt to rape of an 11-year-old as mere sexual assault. And let me give you details first of the incident. We're talking about a minor, an 11-year-old who was returning from a relative's home. The accused men offered a lift to the victim. According to the case, the allegations here, now, these accused grabbed the 11-year-old's chest, they grabbed her breasts. Her pajama string was broken. They tried to drag her beneath a culvert, and then passers-by had intervened and stopped anything further from happening. There seems to be a clear-cut attempt to rape case. And yet, here's what the judge has said. This is the Allahabad High Court judge. He said that groping a minor's breasts is not rape. Breaking minors' pajama strings isn't rape. These are what exactly the court has said. Dragging minor beneath the culvert is not rape. There was no attempt to penetrate victim. Now, all of this adds up because penetration is defined as rape. But why is it not attempt to rape? The judge says that charges qualify for aggravated sexual assault and not for rape. Now, the judge has also said here that no charge has been made by the victim that she was undressed or naked, despite the fact that her pajama string was removed. Her pajamas weren't removed, so on that technicality, this is not rape or attempt to rape. And obviously, it's led to so many questions right now about what qualifies as rape, what qualifies as attempt to rape. So we thought we'll break that down for you, explain it as to what the legal definition is of sexual harassment, of aggravated sexual assault, attempt to rape, and then rape. First is sexual harassment or molestation. This is, of course, any physical contact, advances, explicit sexual overtures without the consent of the victim. All of that falls under sexual harassment. Then you have aggravated sexual assault. Now, the term aggravated sexual assault is very specific to pocso cases, to when the victim is a minor. It means outraging the modesty of the minor victim, which could be also removing his or her clothes. So that is aggravated sexual assault. Above that, attempt to rape. Now, when is a case deemed by a judge as attempt to rape? The intent is clearly established that it was an attempt to commit rape. There was an attempt to penetrate. If that can be established, and obviously it's a gray area, we'll talk about that. But if that's established, then the attempt to rape charge is slapped on the accused. Rape, of course, is when there is penetration of any form. It's committed, obviously, without consent. And in this case, you have the rape charge being slapped against the accused. Now, you look at the details that have emerged of what happened in this Kasganj case with this 11-year-old. The details of how her breasts were grabbed, how she was dragged into a culvert, a pajama string was pulled out. It's not rape because there was no penetration based on the definition I showed you. But how is this not attempt to rape? And so, is this just a subjective verdict based on the judge of the Allahabad High Court? Is this based on his view? Or is this a loophole, a lacune in a law which needs to be addressed? How do you go ahead and prove an attempt? How do you prove attempt to rape? This particular case has thrown up that question as well about whether this is a very gray area that needs to be defined. I want to bring in our legal editor, Nalini Sharma, for more details on this. This has opened up a huge debate, Nalini, on social media. Everyone's talking about this particular case and how, looking at the details that have emerged, this should have perhaps been an attempt to rape case. But, you know, the question that I asked earlier, how do you really prove attempt to rape? Is this, a subjective verdict, or is this really a loophole, a gray area in the law?
Well, Akshata, we can talk about this particular case, and the reasoning that has been given by the judge in this case is that there was no evidence to prove that there was, in fact, any attempt to rape that had happened in this case. Why did he say that? The reasoning specifically was that, number one, there was no proof to say that they had penetrated the minor victim in any manner, along with the fact that there were no allegations also made by the woman or the minor victim stating that there was an attempt to penetrate any of her body organs in any manner. They also go on to say that the accused themselves were not undressed, which goes on to prove that it might be a case of aggravated sexual assault, but cannot specifically be said to be an attempt to rape. And lastly, what the court stated is that the evidence in this case that the court has seen, after seeing the facts of the case and analyzing the evidence, they've come to the conclusion that it's not enough to prove that there was an attempt to rape, because there has to be an attempt for penetration to happen for an attempt to rape to be proved. So this was a reasoning given by this court. At the same time, they've said that the summons should be issued and the accused should be tried for aggravated sexual assault. But in this case, the court ruled that this is not going to amount to an attempt to rape or rape in the case, even though the victim was a minor.
Okay, Nalini, thanks for breaking that down for us, because, you know, there's so much talk and confusion about what really is the circumstances of this case, why the judge ruled in the manner that he did. But this perhaps is going to be a larger debate as well. Thanks for joining us, Nalini, because this issue has now reached the Supreme Court.